Morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and I encourage you to speak with your attorney before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. If you are represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in court with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me to address your case from here. When I call your name, if your attorney is not present here in the courtroom, you can let me know that and we will try to facilitate you through that process. However, I ask you not to tell me that you have a private attorney unless you or your family have retained counsel for this specific arrest. You also need to know that here in the courtroom with me, I have attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here with us this morning to help facilitate the morning session and to provide any additional information that may be needed. Some of you may be able to resolve your case here at First Appearances if you are here on misdemeanor or municipal ordinance matters, but understand that that is dependent on what is going on with you personally and your case. For felonies and violation of probation matters where the judge has already set a no bond hold, please understand that that cannot be resolved here at First Appearances. After today, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we get started, I understand we have a number of cases who the jail has requested to be called out of turn. I will go through those cases first. We'll also have a number of cases to be addressed using an interpreter, and we have a number of individuals signed in today. So we'll move through them as efficiently as possible this morning. The first individual that I have in my stack here is Sean Sheary.
He's here present, Judge on Main. He's approaching. Come on up, Mr. Sheary.
Good morning, Mr. Sheary.
Good morning.
Mr. Sheary, you're before the court this morning on count 1, burglary of an occupied dwelling unarmed. Count 2, petty theft, first degree. Count 3, trespassing of an occupied structure or conveyance. Count 4 is a misdemeanor capias. Count 5, burglary with assault or battery. Count 6, battery, second or subsequent offense, domestic violence. Count 7, child abuse without great bodily harm. Count 8, trespassing of an occupied structure or conveyance. I find probable cause for these charges, and I will hear from the parties.
Your Honor, on count 5, the state would be seeking a finding of proof evident or presumption great for first appearance purposes and request that Mr. Sheary be held no bond so that the defense can file for an Arthur hearing. There really is no reason to believe that he is going to leave his mother, the resident of this home, alone. He's already been trespass warned, so he's legally not allowed to go to that home. That's the open trespass case that he failed to appear in court on. Then he goes to the home, unlawfully enters, strikes his mother in front of her granddaughter. The 6-year-old granddaughter spoke to law enforcement, confirming the battery. And then, a week later, he then breaks into the home again. I do not believe there are any conditions or bond that this court could set that will ensure that Mr. Sheary does not go back to the victim's home. Additionally, Mr. Sheary's out on a felony case right now, attempted burglary of a conveyance. His history includes trespass last year, loitering and prowling last year, tampering with evidence, possession of cocaine 2018, drug paraphernalia 2018, theft 2018, theft 2018, loitering and prowling 2018, dealing with stolen property 2012, previous arrest for child abuse and battery, that was dropped. Your Honor, our office also had contact with the alleged victim. She advised that she does not want any contact with Mr. Sheary and she has safety concerns.
Judge, we'd object to the court making a finding of proof, evidence, presumption great at this stage of the proceedings. That's the highest burden of proof we have in the criminal justice system. The state's failed to introduce any evidence, call any witnesses, and based on that alone, they have failed to meet that very high burden of proof. So we would ask the court not to make a finding of proof, evidence, presumption great. And if over our objection the court does make that finding, we would be asking the court to exercise its discretion and set bond for Mr. Sherry.
Thank you, Mr. Reed. Mr. Romero, is there anything that you want to add?
Not at this time, Judge.
All right. Based on the history that's been presented as well as what I'm seeing in the probable cause affidavit, the court is going to exercise its discretion at this time to make a preliminary finding of proof, evident, presumption great as to count 5. As to count 5, Mr. Sherry will be held without bond at this time. This is without prejudice for him to have a hearing before his division judge to further address that matter. As to counts 1, 6, and 7, State, do you have any recommendation on those?
Yes, Your Honor. On count 1, the state would be requesting a $10,000 bond, and on counts 6 and 7, $2,500 bonds, and an order of no victim contact.
And Judge, Mr. Shuri is indigent, so I'm asking you to take that into account in determining monetary bond for the offenses the state just referred to.
Thank you, Mr. Romero. In light of the no bond hold that's been placed on count 5, I'm going to grant the state's request. I assume he'll be going before his division judge soon, so he'll be able to further address those matters. So the bond on count 1 will be set at $10,000. The bonds on count 6 and 7 will be set at $2,500. There's also going to be an order of no victim contact. Mr. Sherry, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, sir.
Thank you. Kelsey Macklin.
Mr. Macklin is approaching, Judge.
Good morning, Mr. Macklin.
Good morning.
Mr. Macklin, you're before the court this morning on an ad charge. This is a charge for grand theft auto. I find probable cause. I'm not sure what the status of Mr. Macklin's other bonds are, but I'll be
Mr. Macklin has a $100,000 bond on one count and a bunch of no bond juvenile holds.
Okay.
So I'd just be requesting that the $1,000 bond be kept in place.
Judge, considering he has juvenile holds at this time, nothing to add from the defense.
All right, I'll keep the standard bond in place on the new count. Thank you. George Ferguson.
He's approaching, Judge. Here, Maine.
Thank you. Good morning, Mr. Ferguson.
Good morning.
Mr. Ferguson, you're before the court on count 1, grand theft auto. Count 2 is a traffic capias for a temporary tag violation. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing to add from the defense. I'm going to be contacting Mr. Ferguson's family post his monetary bond.
Okay.
Your Honor, the only thing I would request is an order of no victim contact with Modeline Jean.
Is that in reference to count 1?
Yes, Judge.
All right, that's fine. I'll place a no victim contact order. Mr. Ferguson, I don't know whether you know the alleged victim or not, but either way, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir? All right.
Yes, ma'am.
Thank you very much. The standard bonds will remain in place at this time. Jalen Green.
Mr. Green, come on up, please.
Mr. Green. You're before,
Good morning.
You're before the court this morning on count 1, grand theft, greater than $750, less than $5,000. Count 2 is her fraud or uttering a false instrument. I find probable cause, and I hear from the parties.
Judge, Mr. Green, I'm speaking to him. He nor anyone he knows is going to be able to post his monetary bond right now. Mr. Green advised me he is not working. He's looking for. He was previously working at McDonald's. He's a graduate from a Sentinel Charter Academy class of 2018. He lives in Dania Beach with his mother and his grandmother. We're asking the court for releasing him on pretrial release.
Your Honor, I don't have an objection to pretrial release. Just ask, in an abundance of caution, no return to the Sunshine State Academy Elementary School.
That's fine. All right, I'm going to ROR Mr. Green on counts 1 and 2 to standard pretrial. Mr. Green, there's also going to be a no return order. Whether you've ever been to this location or not, there will be a no return order to the Sunshine State Academy. Additionally, Mr. Green, though you're being released to pretrial, you're getting some information there from your attorney. Upon your release, you have 24 hours to report to pretrial. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Okay.
All right, thank you. Donald Cooper,
Approaching, Judge.
thank you. Good morning, Mr. Cooper. You're before the court on count 1, burglary of a dwelling, structure, or conveyance while armed. Count 2 and 3 are both felony capiases. Those each have no bond holds and are not for magistrate. I find probable cause. I'll hear from the parties if they wish to be heard.
Your Honor, the state would be seeking a finding of proof evident or presumption great on count 1 and that Mr. Cooper be held no bond. The incident was witnessed. There was a witness to the incident. Mr. Cooper made a confession to committing the act, and it was captured on ring video footage. I would ask that the court, should the court find proof evident or presumption great, that you not exercise discretion in setting a bond, noting that he has a pending felony matter that he did not appear in court on, and Mr. Cooper is also a registered sexual offender from a 1999 offense that he was sentenced to 18 years in state prison on, and was most recently released from state prison June 21st, 2019.
And we would object to the court making such a finding at this point in time of the proceedings, that being the highest burden of proof that the state can possibly have to meet. Having called no witnesses, introduced no evidence, we would ask the court not to find proof evident presumption great at this time. If over our objection the court does find such a ruling, we would ask the court to exercise its discretion and set a bond for Mr. Cooper.
In light of the information that I have before me at this time, in this case, I am going to make a preliminary finding of proof evident presumption great in order that Mr. Cooper be held without bond as to count 1. That is without prejudice for him to have a hearing before his division judge to further address that matter. Jean-Pierre Baptiste.
Judge, he's here present name, but
Yes.
my understanding is private counsel, Mr. Andrew Coffey.
Do we know anything about that?
Yeah, I've been trying to reach him, Judge, so we can put it on.
All right, so I'll put him on recall. Thank you very much.
Very good.
All right, do we have a Spanish interpreter? waiting on our Spanish interpreter. I know that I have someone that signed in, but we need an interpreter on that case. So let me just go. I know we have families signed in on a few cases. So I'll address some of those if the jail has them. On page 1, Philandria Felton.
I believe North Broward.
She has family present.
Yes, Judge, she's in North Broward.
Okay, thank
And also
you.
she has family members present.
Thank you.
North Broward, Your Honor.
Thank you very much. All right. Good morning, Ms. Felton.
Good morning.
Ms. Felton, you're before the court this morning on counts 1 and 2 are each a count for aggravated assault with a deadly weapon, domestic violence. Count 3, violation of an injunction for protection, that is domestic violence. Count 4 is criminal mischief, $200 or less, first offense. I find probable cause for these charges, and let me first address, we have a number of people who are here for Ms. Felton. So let me just ask first, is everyone going to be speaking separately, or is there just one person? I see we have James here as well. Okay, so let me just first start off with, whoever wants to tell me something, just tell me who you are first, and I have a couple of preliminary questions to ask you before you say anything. Okay, hi ma'am, how are you?
My name is Lydia Beckford, and I am an aunt.
You're her aunt? Okay, are you here to just observe the hearing this morning, or is there something that you want to say?
I'm hoping to provide a character reference. on
Okay,
her behalf.
all right, so let me just say this first. I'm gonna have you placed under oath, and I want you to understand, because you are here without an attorney this morning, that everything we say is being recorded and can be used at a later date. Do you understand that? Okay, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes,
Okay, please state your name and spell your last name for the record.
Lydia Beckford, Beckford.
All right, Ms. Beckford, what do you want to tell us?
Just wanted to speak on behalf of Philandria, just to say some words on behalf of the family, that she's grown into a vibrant young lady that lights up every room she enters. She's always been determined to succeed. She's worked very hard to be successful. She's completed college education, earning a double major degrees as a single parent, raising her child alone in a college setting. That college setting became her community, her village that assisted her and supported her. As a family, we're very supportive of Philandria, and she's pursued as a graduate and educator. She's been an educator with the local school district. She's worked as an educator within youth facilities, which became a passion for her, where she worked as a mentor and encouragement for young children. She continues this desire and looks to do that on a daily basis. She's a nurturer and protector, which comes naturally to her. She's loves fiercely. She loves her daughter. She's a mother, as I say, a single mother, and that's become her world. She calls her dream, and she would encourage anyone who sits down and is engaged in a conversation with her. She's very knowledgeable, very skilled. She's very determined and very passionate to be successful in life. Her goals is always foreseen to be for her and her child. She works feverishly for her child. What we like to do is her path has been carved out, and she's been moving along successfully. Unfortunately, through unforeseeable losses and trials and tribulations, which we all experience, that is something that she's been experiencing the last few years. But she's still that great person inside and out. She will give her last to anyone. So as her family, we just want to provide some type of light on an unfortunate situation for her. Okay? Thank you.
Ms. Vicenta Taylor. Good morning.
Taylor?
Yes, ma'am.
Okay, and do you wish to say something? Just tell me yes or no first.
Yes.
Okay, and you heard what I said before. Everything that we say is being recorded and can be used at a later date. Okay? All right, will you raise your right hand, please? Do you swear or affirm to tell the truth?
I affirm.
Okay, and will you please just state your name and spell your last name?
My name is Vicenta Taylor, Taylor.
Thank you, Ms. Taylor. What would you like to tell us?
I am a human resource director for the city of South Bay, and Ms. Felton is an employee I've known Ms. Felton for several years now. She has started at a part-time position with us and moved on to a full-time. Her character and her determination to be successful, I've seen that within her. No need to say what her aunt has previously said because I mimic everything that she says. She's determined to move forward in her life, determined to see a lot of progress and growth. She's very smart, very educated and passionate about what she does, and I know that she has a lot of passion for her daughter, a lot of passion for her family. So I just hope that there's compassion on her today. Thank you.
Thank you, Ms. Taylor. All right. And I see James standing back there.
Yes, ma'am.
James, is there anything that you need to tell me this morning?
Yes, I did speak with the mother who was able to speak at this current time.
Okay.
But they are limited in funds. I think they're able to only come up with between $750 and $1,500 total. And that's with trying to reach out to family and try to get assistance.
Okay. All right. Thank you.
And I would add, Judge, that Ms. Felton has been a resident of Florida her entire life. She is a code enforcement officer. She has no prior criminal convictions from what she told me. She is a registered voter, and she would be living with her grandmother. She self-surrendered, which I think is very important. And obviously, she has tremendous ties to the community.
State.
Thank you, Your Honor. I know the court has been given a lot of information so far. Unfortunately, what I'm looking at doesn't really gel with what the information the court's been receiving. I can tell you right now, she was arrested in 2016 in Palm Beach for child abuse. She ended up pleading that out to culpable negligence, inflicting injury. As mentioned in the affidavit, she has a pending case right now in Clewiston for violating an injunction against a different individual. The individual she allegedly called in this case, telling her that the victim's children will become orphans, a clear threat to kill the victims in this case, Your Honor. I can tell you our office has had contact with the alleged victims. They are in extreme fear of the defendant, Your Honor. You see the evidence in this case. Soon thereafter, getting off the phone with her daughter, she shows up at the victim's residence. She tries to run him over. She makes a threat with a firearm. She makes threats to his wife, and this is captured on Ring camera, Your Honor. And all of this occurring after a judge in Palm Beach County, after hearing evidence, determined that he or she needed to issue an order for her to stay away from this individual for a year. And in direct violation, again, of that, she showed up at the house and essentially threatened his life. I understand the information that the court's been provided, and I understand that she turned herself in. But none of that really, in my opinion, negates the threat she poses to the victims in this case, and that she has already shown that she is willing to disregard not just one, but two different judges' orders to stay away and not have contact with individuals. Excuse me. Your Honor, the state would be requesting bond in the following amounts: $20,000 on counts 1 and 2, $10,000 on count 3. Should she post her bond's pretrial release with a GPS monitor, no victim contact, no possession of any firearms, weapons, or ammunition.
I don't think that Ms. Felton would have any complaints about the special conditions that the state is requesting. However, from what I'm hearing, that bond may be too high for the family to meet.
What's your recommendation, Mr. Reedy? Mr. Reedy, what's your recommendation as to monetary bond?
I'll put that up to you. What do you recommend?
Well, I would object to that. Really, in fairness, Mr. Jones is not in a position to be making recommendations for bond. He's not an attorney involved in the matter.
$5,000 on each count, Judge.
Your Honor, I don't believe that is even close to serve as a sufficient deterrent, considering her numerous willful violations of court orders to be around people that there's been violence against in the past.
And again, Judge, you could impose a $5,000 bond on each count, and whatever other conditions you felt were necessary, I'm sure that Ms. Felton would be amenable to conducting herself accordingly.
She hasn't so far.
Right. I'm going to impose on counts 1 and 2. Will each be set at $10,000. Count 3 will be set at $5,000. We also have count 4. Ms. Felton does post her bond. She'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be a no victim contact order, which should go without saying based on the injunction that is in place. However, Ms. Felton, so that you understand, no victim contact as it applies to both of the individuals in this case means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, ma'am?
Yes, ma'am.
All right, there's also going to be an order that Ms. Felton possess no weapons, firearms, or ammunition. If she is in possession of any of those items, then she is to surrender them to law enforcement until further order of the court. Ms. Felton, do you understand that?
Yes, ma'am.
All right.
Is the court putting a feet restriction for the purpose of the GPS?
Yes.
Your Honor, and I know it's usually customary for 500 feet. I would ask for an extended based on the allegations.
I was going to place 1,000.
Thank you.
Ms. Felton, as a condition of your pretrial release, you are going to be on a GPS monitor. There's going to be a 1,000-foot stay away. That means that you are not to be within 1,000 feet of either of the alleged victims in this case. Do you understand that?
Yes, ma'am.
All right. Thank you.
What's the GPS monitor?
It's probably more for pretrial. She does, just speaking with human resources, she has to give a schedule. So I just want to make sure she can give a schedule to pretrial.
And level 2, which means that she'll be able to work. That'll all be dealt with pretrial.
Thank you.
Thank you.
I'm confused.
Good luck, Ms. Felton.
Thank you.
Thank you. Okay,
All right, I'm going through the individuals that have people signed in for them. The next one that I have on page 5 is Ololada Shokunbi. Good morning. Do we know which facility she's at? She at Maine?
She's here at Main, Judge.
Okay.
It's your private counsel, Mr. Strandell.
All right. Good morning, Counsel.
Morning, Your Honor. Clark Strandell on behalf of Mr. Kumbi.
Okay.
Your Honor, Judge Merrigan has already found probable cause on this matter.
Yes,
And has already set an order setting bond.
that's correct.
So at this point, I would ask to leave it as is if Your Honor would. And
Okay.
we'll address it with Judge Merrigan at a future point.
I spoke with Mr. Strandell. I'm not asking for any kind of bond increase. The only request I would make, Your Honor, and I guess it would have to be put on the record, if the court would keep the special release conditions, special bond conditions that Judge Merrigan set in place as well.
I'm not asking to change anything this time, Your Honor.
And the bond that was set by Judge Merrigan, as well as the special bond conditions that he outlined in the warrant, will remain in place at this time. I see there was family signed in for her. Is there anyone that wishes to speak, or are they just here to observe?
here to observe.
Okay,
Thank you,
all
Carmen.
right. Thank you very much. Thank you, Mr. Coombe. All right, I also have someone signed in on page 28, Kayron Mikaira Pollard. Do we know where Mr. Pollard is? Maine? Okay, thank you.
He's, here at Main, Judge, but I haven't had an opportunity to speak to him.
Okay,
He's
all right. He
hard
has,
cut off
I'm sorry?
of Mr. McKire.
Do you need a few minutes to speak to him?
We need to bring him, and then I need to speak to him. Yes,
Okay,
Judge.
all right. He has family present, so just let me know when he's ready and I'll call him
No
back up.
problem, Judge.
All right, ma'am, I'll call him back up in a few minutes when they're ready.
Thank you very much.
You're welcome. Okay, do we have an interpreter present yet? No. All right, then I'll do,
One, but he escaped,
Okay.
so I will call for another one.
all right, and Mr. Plant has stepped out as well, so the city cases will wait. What were we doing with Jean-Pierre Baptiste? Do we need more time?
Hey, good morning. We're
Oh,
ready for
okay,
the
here we
Spanish
go.
interpreter in front of Judge
All right, good
Coffin
morning,
now.
council.
Judge, nice to meet you. My name is Andy Coffey.
Nice to meet
Okay,
you too,
do the
Mr.
best you can.
Coffey. Okay,
Okay,
where
thanks
do
so
we
much.
have Mr. Batiste? Is he at Maine?
Here at Main. Mr. Batiste, come on up. There's your private attorney, Mr. Coffey.
Thank you. All right, good morning, Mr. Batiste. Your private attorney, Mr. Coffey, is here in court with me. For the record, you're before the court this morning on count 1, robbery with a firearm. Count 2 is aggravated battery. I do find probable cause, and I'll hear from the parties.
Your Honor, I've spoken about this matter with Mr. Coffey this morning. My understanding is Mr. Batiste will be seeing Judge Merrigan tomorrow. Is that it?
Judge, just so you know, this case was direct filed, but I was talking to Gloria Michelle, Maria Schneider over at the State Attorney's Office. They've agreed that they are going to direct file him, but they're going to be offering him juvenile sanctions. So I got the case number last night. I went to Judge Merrigan this morning and asked him to put it on for tomorrow with the hopes of us resolving the case tomorrow.
So really, just to jump through the legal hoops for today, I would be asking the court to make a finding of proof evident or presumption grade on count 1. And I talked about this with Mr. Coffey. I think we have an agreement for a $10,000 bond on count 2. And then abundance of caution order, no victim contact, no firearms, weapons.
That's fine, Judge. Like I said, he's going to be headed to a level 10.
All right, then, for the record, I'll make a preliminary finding of proof evident presumption great as to count 1. That will be without prejudice for his division judge to address. On count 2, the bond will be set at $10,000. There will also be a no victim contact order and an order that Mr. Batiste possess no weapons, firearms, or ammunition. Mr. Batiste, 2 things. 1, on the no victim contact order, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that? Okay, and on count 2, or excuse me, on the second order, which is the no weapons, that means if you are in possession of any of those items, then you are to surrender them to law enforcement. And your attorney will discuss that further with you following the hearing. All right, thank you very much,
Judge,
gentlemen.
very nice to meet you again. Thank you.
Same here, thank you. That are going to be called out turn. I'm just going to start going through the stack. The next one I have is Erica Lovesmith. Do we know which facility she's at? She's at North Broward?
North Broward, Your Honor.
Thank
It's a
you.
medical reset for Love Smith.
Okay, thank you, Deputy.
You're welcome.
Bernice Sturprals. where Mr. O'Pralls is?
She's here at Main Judge.
Thank you. All right, good morning, Mr. O'Pralls.
Good morning.
Mr. O'Pralls, you're before the court this morning. Count 1 is a misdemeanor capias. Count 2 is a felony violation of probation with a no bond hold. I find probable cause. I'm going to leave the bond in place on count 1. You have a hearing before your division judge tomorrow morning, Mr. Opolis. Thank you. Julie Lancaster.
North Broward, Your Honor, another medical reset.
Okay, thank you. Thank you, Deputy.
You're welcome.
Tori Ann Hewitt. Thank you very much. Good morning, Ms. Hewitt.
Good morning.
Ms. Hewitt, you're before the court this morning on an ad charge. This is a charge for aggravated battery with a deadly weapon. Do the parties wish to be heard on this? Based on what I'm seeing on count 1, there was a, Judge Powell found proof evident presumption great.
Yes, Your Honor, and this is part of the same case. In light of that, I'd be requesting a $10,000 bond. I believe there already is a no contact order in place.
Yes, I see that. Mr. Reedy, anything that you want to add on this? Okay. All right, then I find probable cause for the ad charge, and the bond will be set on that at $10,000. All right, thank you, Ms.
Okay.
Hewitt.
Thank you.
Okay. Jason Pitts.
It's already signed.
This is here at Main.
Good morning, Mr. Pitts.
Good morning.
Mr. Pitts, you're before the court this morning on 2 out-of-state felony holds. Count 2 has a no bond hold. Since these are out of state, you'll be going before the extradition judge to address what's going to happen with these matters. I find probable cause on both of them, and you should be going before the extradition court shortly. Thank you.
Your Honor, I don't know if you have them in one of the piles. There were 2 female domestics.
What are the names?
Did we do one? I had Isabella Rodriguez and Hernandez Escobar.
Yes. And Hernandez Escobar needs a Spanish interpreter, so
Oh,
I
does
have
she?
to.
Okay.
But I can
Yes,
do.
but I don't think that Miss Rodriguez does.
Okay, we can do Isabella Rodriguez. Do we know which facility?
She's in Paul Ryan.
Okay.
Just wait by the turn.
Okay, good morning, Ms. Rodriguez. Ms. Rodriguez, you are before the court on 1 count of aggravated battery where the offender knew or should have known the victim was pregnant. This is domestic violence. I find probable cause, and I'll hear from the parties.
Your Honor, state would be requesting a $1,500 bond and no victim content.
Judge, I can say Miss Rodriguez, I believe, from what she told me, has no prior contact with the criminal justice system. She's been living in Florida since August. She has provided me with the name and number of her mother, who she is hoping she could post bond with, but who she would be living with. So she does have a stable residence. I'd ask the court to consider pretrial release under these circumstances.
State, does she have any priors?
No, Your Honor.
All right, I will grant the request and release her to standard pretrial. There's also going to be a no victim contact order. Ms. Rodriguez, a couple of things for you to know. No victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Okay, additionally, you're going to be released today. Before you are released, you're going to get some information from the jail there about pretrial supervision. You must report to pretrial within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes.
Okay. All right. Thank you, ma'am.
Thank you so much.
Look.
have is Ajanti Myers.
Mr. Myers is approaching, Judge.
Thank you. Good morning, Mr. Myers. Mr. Myers, you're before the court this morning on count 1, aggravated assault with a deadly weapon, domestic violence. Count 2 is battery causing bodily harm. That is also domestic violence. I find probable cause, and I'll hear from the parties.
What was that? Your Honor, I'm gonna be requesting a $15,000 bond on count 1, $5,000 bond on count 2, pretrial release of the GPS monitor, no victim contact. At this point in time, without more information, I'm very concerned, not just for the safety of the victim, Mr. Myers' family, but frankly, I'm also concerned for Mr. Myers' own safety. In law enforcement presence, he made threats to harm himself. As the court's aware, he admitted to attempting to kill his father with a butcher knife. What's even more concerning is his comments as to not only that his intent, but why he was going to do it and why he believed there would be no issue with him or legal issue with him committing that act. I would note he's 18 at the age of, I guess in 2015, I'm being advised he was arrested in Jacksonville for aggravated battery, but it appears that charge was dropped.
Mr. Romero?
Judge, I believe the alleged victim is his stepfather, in which his stepfather and Mr. Myers basically have not been getting along. Unfortunately, it escalated. My understanding, Judge, though, he's 18 years old. He's working. He works for a company called Aero Science. He spins the science. He only gets about $10 an hour. There's no one that's going to be able to post his monetary bond. I did advise him the court's going to impose a no contact order. He said he will abide by that contact order. He's going to have to find a place. He really doesn't have a place to stay. So, Judge, at this time, unfortunately, financially, he can't post a bond and he has no other place to stay.
Concerned by some of the allegations that are included in the probable cause affidavit, including some of the statements that were made by Mr. Myers himself to law enforcement. I'm not sure if there were other issues going on that I'm unaware of, but based on the circumstances, at this time, I'm going to set a $15,000 bond on count 1, a $5,000 bond on count 2. If he does post his bond, he'll be placed on pretrial with a level 2 GPS monitor. There's also going to be an order of no victim contact. Mr. Myers, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Okay. Given the circumstances, I'm also going to impose an order that Mr. Myers not possess any weapons, firearms, or ammunition. Mr. Myers, that means that if you are in possession of any of those items, you are to surrender them to law enforcement. Do you understand that, sir?
Yes, ma'am.
All right. Thank you. Yes. Thank you. Next is going to be Jose Reyes Sanchez.
He's approaching, Judge. Here, ma'am. Come on up, sir.
Good morning, Mr. Reyes Sanchez.
Morning.
You're before the court this morning on count 1, battery causing bodily harm, domestic violence. Count 2 is tampering in a misdemeanor proceeding. I find probable cause, and I'll hear from the parties.
I'd be requesting a $3,500 bond on count 1, a $1,500 bond on count 2. No victim contact. I would note Mr. Reyes Sanchez currently has a $2,000 warrant from 2018 out of Dade County for failure to appear in court. I am concerned, based on the victim's statements to law enforcement, that there's a history of undocumented violence against her by Mr. Reyes Sanchez. And when posed with the risk assessment questions and asked did she think that Mr. Reyes Sanchez is capable of killing her, she answered in the affirmative.
Judge, I didn't hear what was the state's request on the monetary bond.
They're requesting $3,500 on count 1, $1,500 on count 2, no victim contact.
Judge, hold on. Judge, at this time, considering the circumstances, that would be reasonable. We're just asking for the court to also enter a photo order so we can photograph the injuries Mr. Reyes sustained as well.
All right, I'll sign the photo order. Once again, the bond's gonna be set at $3,500 on count 1, $1,500 on count 2. There's gonna be a no victim contact order. Mr. Romero, since there is no victim contact, I just need to know, I assume these two individuals reside with each other. Does he have someplace else to go and he understands that?
Yes, Judge, I did advise him of that. You'll find a place.
All right, so Mr. Reyes Sanchez, the no victim contact order means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
I understand that, Your Honor.
All right, thank you. Jeremy Brown,
North Broward?
thank you.
North Broward, Your Honor.
Thank you.
You're welcome.
Good morning, Mr. Brown.
Good morning, ma'am.
Mr. Brown, you're before the court this morning on count 1, second-degree petty theft, first offense. Count 2 is a felony probation violation with a no bond hold. I find probable cause. And Mr. Brown, on the probation violation, you're gonna have a hearing before your division judge tomorrow morning.
Okay,
All right? Thank you very much.
thank you.
Heath Smith.
Yes, ma'am.
Thank you. Good morning, Mr. Smith.
Good morning.
Okay, Mr. Smith, you're before the court this morning on 2 change of charge counts and stated, just want to make sure I have these right. On count 5, I have that the assault domestic violence charge is being changed to touch or strike battery. Count
Yes,
count 6, which was burglary of a dwelling structure, conveyance while armed, is being changed to aggravated assault with a deadly weapon without intent to kill. Is that accurate, State?
That is 100% accurate, Judge.
Okay, all right.
If I could, may approach,
Yes.
because the aggravated assault previously was a punishable by life offense where he had no bond, and he's gonna need to have a bond set today. I have the PC, so.
right. I find probable cause for these charges. I'll hear from the parties.
Thank you, Your Honor. Well, court is familiar with these allegations. These are extremely a high level of violence alleged, threatened to kill the victim, put a knife to her throat, committed these acts in front of the children. One of the children with a serious physical condition, telling both children to say goodbye to their mother. And I would want to advise the court, when Mr. Smith was first arrested on these charges, he was also, these allegedly occurred December 9th. He was also charged with burglary with structure in violation of an injunction against the same alleged victim, and that occurred on the 12th. His arrest on the 12th was based on that incident. His bond on those charges is $7,500. Based on the allegations in this case, I'm requesting a $25,000 bond on count 6, $5,000 bond on count 5, pretrial release of the GPS monitor, level 1, no victim contact, no contact with either of the children mentioned in the report. Your Honor, because they were present, they could both be considered witnesses, and no possession of any firearms, weapons, or ammunition.
Judge, he's already got a $8,000 bond on his other charges, which apparently he's not able to make. I'd ask for $1,000 on each count. With, of course, whatever conditions, including no contact, that the court felt was appropriate.
Burglary of an occupied structure in violation of an injunction.
Honestly, those charges aren't before me today, and I haven't read the probable cause affidavit for those charges, but with regard to the charges that we are dealing with today, these are obviously extremely serious allegations and a cause of great concern for the safety of both the alleged victim and potentially the minor children. Based on these allegations, I'm going to impose a $15,000 bond on count 6. Count 5 will be $5,000. If Mr. Smith does post his bonds, he'll be placed on pretrial supervision. Mr. Reedy, I'm trying to make a determination as to whether I want to place him on level 1 or level 2. Does he work?
No, ma'am.
Okay, all right. Then he'll be placed on level 1 with a GPS monitor. There's also going to be a no victim contact order. There will also be an order of no contact with the 2 minor children that are referenced in the probable cause affidavit until further order of the court. There will also be an order that Mr. Smith possess no weapons, firearms, or ammunition. Mr. Smith, that means if you are in possession of any of those items, you must surrender them to law enforcement. Do you understand that?
Yes, ma'am.
Additionally, with regard to the no contact orders, in addition to not being in the same place at the same time, there will be a 500-foot stay away as part of your pretrial supervision. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am. I don't have a phone. Yes, ma'am.
All right, thank you. Thank you, Mr. Smith.
Whenever the court's ready, we're ready to proceed on Mr. McKayer, who was on the recon page
Okay.
28.
Thank you.
Excuse me, Paul Ryan.
Yes, let me go to Paul
Could you have
Ryan.
Mr. Edie contact Paul Ryan for a second?
Mr. Reedy, will you contact Paul Ryan for a moment? They're requesting you. Paul Ryan is requesting that you contact them. Okay, thank you. All right. Okay, so we have Mr. Micaiah Pollard. And
Yes,
he has family present. Good morning, Mr. Pollard.
Morning, ma'am.
Mr. Pollard, you're before the court this morning on one count of burglary of an unoccupied dwelling, unarmed. I find probable cause for these charges. And first, hi folks, are you his parents or family? Okay, are you here to observe or are you here to tell me something? Just tell me which one first and then we'll go through some questions. Okay. All right, so a couple things that I say to everyone. Everything that we say is being recorded and can be used against him or against you at a later date. You're here without an attorney. Do you understand that?
Yes, ma'am.
Okay, and do you still wish to say something? Just tell me yes or no. It's okay.
About it as you talk.
Sure. Well, here's what I'm going to say to you. If you do want to tell me something, then I'm just going to place you under oath. So if you want, I can go ahead and do that. And then if you decide you want to tell me, then we'll do. Okay. All right. Do you swear or affirm to tell the truth? Okay. And will you please state your name and spell your last name for the record?
My name is Ruth Micaiah Pollard.
Thank you, Ms. Pollard. Okay. And is this your husband next to you?
Yes.
Okay. All right. Hi, Dad.
Hello.
And Dad, are you going to be saying something as well this morning? You're just going to listen. Okay. Well, let me know if you change your mind, and if you do, then I'll place you under oath and we'll go through it, okay? All right. So, Ms. Pollard, is there anything you want to say right now?
He's a good kid. I want to let you know this. He helps me a lot because they placed 2 IBC filters in me, and he's my right hand. And I don't know what I would do without him. And he have a job. He's really turning his life around, and I'm very proud of him. He's a good kid.
Is there anything else that you want to tell me?
No, ma'am.
Okay. All right. So let me hear from the attorneys, and then we'll figure out what we're going to do here. All right.
Your Honor, I'm going to be requesting a $3,500 bond, no victim contact, no return. Frankly, I'm taking into consideration his age, what his mother had to say. I certainly can appreciate what his mother has to say. That being said, it is alleged that he unlawfully entered someone's their property, the property of their residence where they live, stole their property. His explanation really doesn't seem credible to me, that because a neighbor told you you could go onto someone else's property, that was a basis to it wasn't like it was the person's property saying, yeah, you can come onto my property. It was someone else's property. He does, as a juvenile in 2017, hit a grand theft auto. He did go through a diversion program.
Yes, sir. Yes, ma'am.
Judge, as you heard, Mr. McKayer has very limited contact with the criminal justice system. He went through the diversion program, so he basically has a clean record. He's 18 years old, had very strong ties to the community. He's been here his whole entire life. Actually, he's a registered voter. Judge, he's actually working. He works full-time at Popeyes. He's been doing that for 2 years. And also, he's currently attending Atlantic Technical Monday through Friday from about 8 a.m. to 12 noon, trying to obtain his GED. He appreciates his mother and father being here for support. He's sad to see him here under these circumstances. Judge, my understanding is and I'm sure there's two sides to every story, but I think Mr. McIr's age plays a large part on being naive. My understanding, and speaking with Mr. McIr, he thought he got permission from a person that had the authority to give permission, told him that, yeah, I do scrap metal, I get like the aluminum, whatever I can get. He goes, oh, I have two window panels, you can go and get them. So he thought it was legitimate. He went. He actually rung the doorbell to go ahead and try and meet up with that person. No one answered. He saw the window panels. It wasn't inside the home. It was on the driveway. And Judge, that's what happened. He actually tried to, when he was confronted by law enforcement, he tried to give law enforcement the identity and specifics as far as where they can actually speak to this individual that gave him this authority, but they wouldn't hear of it. Judge, I have no doubt that Mr. McIr will be coming back to court, but unfortunately, from what he advised me, his family doesn't have a lot of financial resources. I don't know if they're going to be able to come up with the $3,500. What I was going to be requesting is a $1,500 bond on Mr. McIr's behalf, Judge.
And I promise this will be the last thing I have to say, but if you think about it, the ringing of the doorbell, if his interest really was to procure the permission of the person who lived there, then he would have come back. What it seems to be is that he rang the doorbell, and once he confirmed that there was nobody there, then it was safe for him to take the windows.
Right, Mom, you have something else you want to say?
Respect, this is what my husband do for a living because we're on disability and we are indigent. And I know my son is really worried about me because I just went to the doctor yesterday and they evaluations of my health is not very well. And he knows the protocol to go and ask, and I really don't believe, you know your children, and we all want to think the best. I don't believe that he went to steal because he knows we are Christians, and I don't say that very lightly.
All right, thank you, Mom. All right, without going into what's going on in the case, I'm not going to make any speculation as to what may or may not have happened, but I am going to grant the defense's request and place a $1,500 bond on count 1. There's also going to be a no return order and a no victim contact order. Mr. Pollard, I don't know if you know the individual homeowner or not, but whether you do or not, that means you are not to go back to that location. And that means, okay, no phone calls, no text messages, no third-party contact, no social media, okay? All right, thank you. All right. All right, thank you, folks. Mr. Romero,
I'm sorry. Yes, sir.
is everything okay there at the main jail?
I'm trying to inquire what's going on.
Okay,
Right now.
thank you.
Judge, it's medical, but right now it's under control. I believe he's getting assistance right now.
Okay, just let me know.
Thank you, Judge.
All right. Mr. Rydell, are you hearing one of the Spanish interpreter cases? Okay, do we know where the interpreter is?
Yes, Judge, I called, and they were all in other courtrooms. As soon as one of them gets free, they'll send him over.
Yes.
In this matter, and I say it only because there's a number of other places I have to be in for the purpose of the record. It's Joshua Rydell on behalf of Maria Hernandez Escobar.
Yes.
And I've talked to Mr. Linder, and maybe when the Spanish interpreter does get here, you can just address it accordingly.
Okay.
We're not going to address probable cause. I'm not making an argument to probable cause if the court chooses to find that fit. I've talked to Mr. Linder about the case, about the situation, and I think we're in agreement of a $2,500 bond and a no contact order. To be ordered, obviously, when the Spanish interpreter gets here, which I think would be obviously the more important prong of why I would have to wait.
I understand. And we're all in agreement about that?
Absolutely, yes, sir.
Okay, then when the interpreter comes, and Mr. Romero, you can explain that. I assume that's who you have next to you, is Ms. Hernandez Escobar. When the interpreter comes, then I will go through all of that with her for the record. That way Mr. Rydell doesn't have to wait on the interpreter.
Thank you, Judge. And in fact, her just lets her know her family did retain me to come and see her today.
Okay, All right. Thank you.
$2,500 and just a no contact order. Your Honor, thank you. It was very nice to see you in this location.
Thank you. Same here. All right, so I'm just gonna put our Spanish cases to the side, and then when the interpreter comes, we'll address them. In the meantime, we'll keep going through our stack here. Next up is gonna be Gregory Laster.
What page, Judge?
Gregory Laster's on page 10.
North Broward,
He
Your Honor.
is North Broward.
Thank you. All right. Okay.
He's in court.
Okay, North Broward, you're killing me today.
Sorry.
That's all right. We'll reset him.
Okay.
Thank you. All right, Devin Palmer.
Copy, Your Honor.
Thank you. All right, good morning, Mr. Palmer. Mr. Palmer, you're before the court this morning on an ad charge. This is count 4, a misdemeanor capias. This is a charge for trespassing. I find probable cause. Is there anything that the parties want to add?
It looks like this is the only thing holding him, Judge. Count 1 was a null pros.
Okay.
Counts 2 and 3 were no infoed. So this is the only thing holding him. So, you know, if Mr. Palmer wants to resolve this today, you know, I think we might be amenable to that if there's a plea offer forthcoming.
State.
Offer is withholding court costs.
Did you hear that, Mr. Palmer?
Say it again.
It's a withheld adjudication, no conviction on your record, court costs, and you'll have 6 months to pay the court costs.
Okay.
And that's the only thing holding you, so you should be out of jail later on this afternoon.
Okay.
Is that what you want to do?
Yes.
Okay.
All right, so Mr. Palmer, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Mr. Palmer, do you understand everything that we've discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And Mr. Palmer, what plea do you wish to enter, guilty or no contest?
No contest.
Okay, I accept your plea and find that it is freely and voluntarily given. And once again, your sentence will be a withhold of adjudication plus court costs. Good luck to you. All right, Mr. Plant, you're up next. Okay, let me grab your stack. All right. I'm gonna see who we've got available. The main jail, I think, they were having some issues today. Okay, so on page 3, Tamara Salkeld.
North Broward, Your Honor, please.
North Broward.
North Broward.
I'm waiting for it.
Here she is.
All right, good morning, Ms. Salkeld.
Morning.
Ms. Salkeld, you're before the court this morning on a misdemeanor capias. This was a municipal ordinance violation for trespassing. And Mr. Plant, what are we doing today?
Judge, it's adjudicate time served.
Adjudication time served?
Yes, Your Honor.
All right. Ms. Salkeld, if you would like to resolve this case today, then the city's offer to you is an adjudication time served.
Yes, ma'am.
Would you like to accept that offer?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Ms. Salkeld, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
She's already in. What?
Have you ever been treated for mental or emotional
Yes.
illness? Okay. Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter? Guilty or no contest?
No contest.
Thank you, Ms. Salkeld. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
Thank you.
On page 3, Lorraine Collins.
That's right, Your Honor.
Thank you. Good morning, Ms. Collins.
Good morning, Your Honorable Judge Campton.
Ms. Collins, you're before the court this morning on 3 municipal ordinance violations. They are for resisting an officer without violence, open container, and disorderly conduct. I find probable cause, and Mr. Plant, what are we doing on Ms. Collins' case
Ma'am,
today?
do you want to resolve your case today?
Yes, ma'am. Yes, sir.
Okay. There will be adjudicate time served, Your Honor.
All right, so Ms. Collins, the offer from the city is an adjudication, time served, if you would like to resolve it today. Do you want to accept that offer?
Yes, ma'am. Yes, Your Honorable McCanton.
Okay.
Miss McCanton.
Ms. Collins,
Compton.
that's all right, Ms. Collins. Everybody mispronounces it. Don't worry about it. All right, Ms. Collins, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes, ma'am. The whole truth and nothing but the truth.
Thank you. Will you put your hand down? Do you understand everything that we've discussed today?
Yes, ma'am.
Is
Yes, Your Honor.
anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been
I
treated?
understand.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
And is there anything about that illness today that impacts your ability to accept this plea?
Absolutely not.
Okay, thank you. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, Ms. Collins? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. And Ms. Collins, once again, your sentence will be an adjudication, time served. Good luck to you.
Look, ma'am.
Thank you. Thank you, Your Honor.
I'm sorry? Yes.
Our Spanish interpreter is present, Judge.
Thank you. I'll do can you wait a few minutes for me? Okay. I know it took a while to get to here. So. All right, let me just finish Mr. Plant's cases, and then I'll do the Spanish cases. Okay, on page 4, Kimberly Kelly.
She might have, I think it's medical.
North Broward Johnson.
All right, good morning, Ms. Kelly.
Good morning.
Ms. Kelly, you are before the court on a misdemeanor capias. This was a municipal ordinance violation for trespassing. I find probable cause, and Mr. Plant, what are we doing on Ms. Kelly's case?
Your Honor, she could resolve her case, adjudicate time served. Would you like that, ma'am?
Ms. Kelly, if you want to resolve it today, the offer is an adjudication, time served. Do you want to accept that offer?
Yes, ma'am.
Okay, will you raise your right hand, please? Do you swear or affirm to tell the truth?
I do.
Okay, thank you. You can put your hand down. Ms. Kelly, do you understand everything that we've discussed here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
I do.
Have you ever been treated for mental or emotional illness?
I have.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you, Ms. Kelly. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
Thank you.
Good luck, ma'am.
On page 11, Vladimir Gasper.
He's in Maine, Your Honor.
Judge, he's approaching. Mr. Gasper, he's going to be requiring Spanish interpreter.
She's here.
Okay,
And
well,
it
good
so,
thing I
just
have
so
an
happens we have one.
All right. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
Yes, I swear.
And will you please state your name?
Sandra Porter.
Okay, thank you. All right, good morning, Mr. Gasper.
Buenos días, señor Gasper.
You are before the court this morning on an ad charge.
Está delante del tribunal esta mañana por un cargo adicional.
This is a misdemeanor capias.
Es una orden de captura por un delito menor.
The charge is a municipal ordinance violation
El cargo es haber violado una ordenanza municipal
for lodging on private property.
por entrar en una propiedad privada.
And Mr. Plant is here, who is representing you.
El señor Plant está aquí, que nos representa.
Mr. Plant, what are we doing with you?
Judge's offer is adjudicate, or no, withhold court, or time served. It's a time served offer.
La adjudicación de tiempo servido. Cumplido.
Okay, so Mr. Gasper, if you wish to resolve your case today,
Okay, señor Gasper, si usted quiere resolver su caso hoy,
the offer is an adjudication time served.
la oferta sería un fallo y el tiempo cumplido.
Do you wish to accept that offer?
¿Usted desea aceptar esa oferta?
Sí.
Yes.
Okay, will you raise your right hand, please?
Sí, levante su mano derecha.
Mano derecha, mano arriba.
Do you swear or affirm to tell the truth?
¿Usted jura o afirma decir la verdad?
Sí, yeah.
Yes.
Okay, you can put your hand
Y
down.
puede bajar la mano.
Mr. Gasper, do you understand everything that we've discussed today?
Señor Gasper, ¿usted entendió todo lo que se habló hoy?
Sí.
Yes.
Is anyone forcing you to resolve your case?
¿Alguien lo está obligando para que resuelva su caso?
No.
No.
Are you under the influence of drugs or alcohol?
¿Usted está bajo los efectos de drogas o de alcohol?
No entendí la pregunta.
I didn't understand the question.
Are you under the influence of drugs or alcohol?
Que si está usted bajo los efectos de drogas o de alcohol.
Oh, no, no, no.
No, no, no.
Do you need any more time to speak with your attorney?
¿Usted necesita más tiempo para hablar con su abogado?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
¿Comprende usted que tiene el derecho de que se le celebre un juicio, pero está renunciando ese derecho al declararse hoy aquí?
Sí.
Yes.
Have you ever been treated for mental or emotional illness?
¿Alguna vez usted ha recibido tratamiento por alguna enfermedad mental o emocional?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
¿Comprende usted que si no es ciudadano estadounidense, al declararse aquí puede resultar o afectar su estado migratorio?
Sí.
Yes. Y sujetarlo, perdón, a deportación.
Sí.
Yes.
And what plea do you wish to enter, guilty or no contest?
¿Cómo se quiere declarar? ¿Culpable o no disputo?
You can say no contest.
¿Puede decir?
No culpable porque este es el mismo caso de ayer.
Not guilty or guilty? Guilty?
Because it's the same
Perdón.
case as yesterday.
Because, yeah.
He's
because
right.
it's- Because it's the same case as yesterday.
Okay, all right, so it's a guilty plea.
I was gonna
Okay,
say-
I accept your plea and I find that it is freely and voluntarily given.
Ok, voy a aceptar su declaración porque encuentro que se ha presentado libremente y voluntariamente.
And your sentence will be an adjudication time served.
Y la sentencia será un fallo y el tiempo cumplido.
Good luck to you, Mr. Gasper.
Buena suerte, señor Gasper.
Good luck, sir. Sorry.
Okay. All right. I have a couple other cases for you, if you'll just give me a few minutes. All right, on page 12, Wilmot Brown. Good morning, Mr. Brown. Mr. Brown, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for disturbing a trash can or dumpster. I find probable cause. And Mr. Plant, what are we doing with Mr. Brown's case?
Your judge's offer is adjudicate time served.
Okay, so Mr. Brown, if you would like to resolve your case today, the offer is an adjudication, time served. Would you like to accept that offer?
It would be time served. It's a time served offer, Mr. Yeah. Okay.
Okay, Mr. Brown, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yeah.
Okay, you can put your hand down. And Mr. Brown, do you understand everything we've discussed today?
Yeah.
Are you under the influence of drugs or alcohol?
No.
Is anyone forcing you to resolve your case?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
No.
Have you ever been treated for mental or emotional illness?
Yeah.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Okay, do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yeah.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, thank you, Mr. Brown. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck.
Okay, thank you.
On page 13, Ernest Blanks.
Mr. Blanks. It's coming up, Your Honor.
Good morning, Mr. Blanks. Mr. Blanks, you're before the court on a misdemeanor capias. This is a municipal ordinance violation or an alcoholic beverage violation. I find probable cause. And Mr. Plant, what are we doing in Mr. Blanks' case?
Mr. Blanks, do you want to resolve your case?
Yes, I would, sir.
Okay. Oh, it's time served, sorry.
Okay. All right, so Mr. Blanks, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes.
Okay, thank you. You can put your hand down. And Mr. Blanks, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
Thank you, Mr. Blanks. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
Thank
Thank
you.
Okay, and then the last one I have here is on page 22, David Hannon.
David Hannon?
See it, me?
Yes.
He's approaching Judge here, me.
All right. Good morning, Mr. Hannon.
Good morning.
Mr. Hannon, you are before the court this morning on count 1, robbery with no firearm or weapon. Count 2 is a misdemeanor capias. That is a municipal ordinance violation for possession of paraphernalia. And let me just take a moment on count 1. Let me just read the probable cause affidavit. One moment. find probable cause. And I will hear from the parties. Whoever wants to go first.
Judge, in reference to the state offense, what I wanted to know as far as the particulars, when was the alleged date of incident and location on that offense?
This was on December 30th. There's an address listed in Fort Lauderdale. Do you need the exact address?
Judge, right now, I don't know if this PCFD reflects it. I know Mr. Hannon advised me that he basically came over here to the main jail and surrendered himself. Right now, he gets disability. He only gets $784. He's 40 years old, been here his whole life. The only person that's going to be able to help him financially to post a bond is his mother. My understanding, she's on a fixed income, gets disability. It's going to be tough as it stands for her to come up with the $2,500, but he's going to try. So, Judge, in reference to count one, at this time, in speaking with Mr. Hannon, nothing to request, but I believe Mr. Hannon wants to request on count number two, I think, something from his attorney in order to resolve that matter today.
That offer is adjudicate time served if he wants to resolve it.
On count two?
Yes, Your Honor, or he'll be in court tomorrow.
All right, we'll address that in a moment. Hear from the state.
Yes.
On count one, I believe the bond that Judge Merrigan set on a second-degree felony involving violence, when the allegation is that Mr. Hannon and another man attacked the victim, punching him several times and choking him until he was unconscious and then robbing him, I believe a $2,500 bond is quite reasonable.
Okay, I'm going to leave the $2,500 bond in place on count one. He has a hearing before his division judge on that count tomorrow morning. As to count two, which is the municipal ordinance violation, Mr. Plant, you said that's an adjudication time served?
Yes, Your Honor.
All right, so Mr. Hannon, only on the municipal ordinance violation count, okay, so we're not talking about the alleged robbery, we're talking about the municipal ordinance. If you want to resolve that count, then the city's offer is an adjudication time served. Do you wish to accept that?
Yes.
Okay, all right, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. Mr. Hannon, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yeah.
And what plea do you wish to enter, guilty or no contest?
No contest.
Okay. Thank you, Mr. Hannon. I accept your plea and find that it is freely and voluntarily given. Your sentence as to count two only will be an adjudication time served.
Thank you, Judge. Good luck, sir.
Thank you. Our Spanish cases. The first one I have is Maria Hernandez Escobar.
Senora Hernandez, ma'am. She's approaching, Judge. Maine.
Thank you. Good morning, Ms. Hernandez Escobar.
Buenos días, señora Hernández Escobar.
Buenos días.
Good morning.
You are before the court on one count of aggravated battery,
Está delante del tribunal con un cargo de violencia con agravantes,
where the offender knew or should have known the victim was pregnant,
donde debió de haber sabido o sabía que la víctima estaba embarazada.
I find probable cause,
Encuentro que ha habido causa probable
And Ms. Hernandez Escobar, your private attorney was here earlier.
Y señor Hernández Escobar, su abogado privado estuvo aquí más temprano.
Sí.
Yes.
The agreement of the parties is that bond will be set at $2,500.
Y el acuerdo entre las partes fue que la fianza se va a poner a $2,500.
There will also be a no victim contact order.
También se va a emitir una orden de no poder tener contacto con la víctima.
Ms. Hernandez Escobar, no victim contact
Señor
means
Hernández Escobar, no contacto con la víctima significa
no phone calls,
no puede haber llamadas,
no text messages,
ni mensajes de texto,
no social media,
no puede haber por los medios sociales,
no third party contact.
yes, y no puede haber contacto por una tercera parte tampoco.
Do you understand all of that?
¿Usted comprende todo eso?
Sí, pero si nosotros vivimos en la misma casa.
Yes, but we live in the same house.
Ms. Hernandez Escobar, you will have to find someplace else to stay for the time being.
Señor Hernández, entonces por lo tanto tendrá que buscarse otro sitio donde vivir mientras tanto.
¿Quién, yo
Who, me?
o ella?
Or her?
You for now. You can discuss it with your attorney.
Usted por ahora, háblelo con su abogado.
Okay.
Okay.
Okay, thank you.
Gracias.
Okay.
Next will be Iramis Gonzalez Cabrera.
She's approaching Judge in Maine.
Thank you. Morning, Ms. Gonzalez Cabrera.
Buenos días, señora González Cabrera.
Buenos días.
Good morning.
You're before the court on one count of carrying a concealed firearm.
Está usted delante del tribunal por el cargo de portar un arma de fuego oculta.
I find probable cause.
Encuentro que ha habido causa probable.
I'll hear from the parties.
Escucho de las partes ahora.
Nothing to add from the defense, Judge.
Anything from the state?
Only thing I'd request, no possession of any firearms.
Pedimos que no
for
haga
further
posesión de
report.
ningún arma de fuego.
All right, then the standard bond will remain in place.
La fianza estándar seguirá vigente.
And Ms. Gonzalez Cabrera, there will be an order that you possess no weapons, firearms, or
Sí.
ammunition.
Señora González Cabrera, habrá una orden donde dice que usted no puede portar armas de fuego ni municiones.
That means if you are in possession of any of those items,
Quiere decir que si usted está en posesión de cualquiera de esos artículos,
you are to surrender them to law enforcement until
Se-
further order of the court.
se los tiene que entregar a algún agente del orden público hasta que haya otra orden del tribunal.
Do you understand that, ma'am?
Señora, ¿usted comprende eso? Yes.
Yes.
All right, thank you.
Gracias.
Mauricio Lopez, on page 15.
Hey, Judge.
Good morning, Mr. Lopez.
Buenos días, señor López.
Buenos días.
Good morning.
You are before the court on 2 misdemeanor capiases.
Usted está delante del tribunal por 2 órdenes de captura por delitos menores.
One is for violation of a Broward County ordinance.
Una es por violar una ordenanza del condado de Broward
The other is for operating without a valid license.
y la otra es por conducir sin tener una licencia válida.
I find probable cause.
Encuentro que ha habido causa probable. Ya se prestó la fianza.
And confinement has advised that your bond has been posted.
El departamento de confinar dice que ya se prestó su fianza, ya se pagó.
I do see on here that Mr. Lopez has a hearing set in front of his division judge tomorrow morning.
Ya veo aquí que el señor López tiene fijado una audiencia delante de su juez en esa división mañana.
Judge, my understanding, he's posted bond, I believe that court date will be deleted.
Let me just make sure.
Como pagó la fianza, ya se anuló esa fecha.
May I ask the Lopez? Yes. All right. That's accurate. Thank you, Mr. Lopez.
Es correcto, gracias, señor López.
Jacinto Correa Valesco, on page 18.
Mr. Corio Velasco, ven por favor.
Good morning, Mr. Correa Valesco.
Buenos días, señor Corio Velasco.
Yeah.
Yes.
You are before the court on 2 felony capiases.
Está usted delante del tribunal por 2 órdenes de captura por delitos graves.
There is a third count for a misdemeanor capias.
También hay un tercer cargo por una orden de captura por delito menor.
The two felony capiases each have no bond holds and are not for magistrate.
Los 12 de delitos graves no es para el magistrado y no tiene fianza.
I find probable cause.
Encuentro que ha habido causa probable.
You have a hearing before your division judge tomorrow morning.
Usted tiene una audiencia delante de la juez o del juez de su división mañana por la mañana.
The standard bond will remain in place on count 3 at this time.
Y se queda la fianza estándar por el cargo número 3 en este momento.
Yes, Judge.
Thank you. Okay. Is there anyone else at Maine that needs a Spanish interpreter?
Not here at Maine, Judge.
Okay. Anyone at any of the other facilities need a Spanish interpreter?
Not as I've been advised, Your Honor.
All right. Thank you very much. Okay, so I'm going to start going down our stack now. James Jones.
Judge, he's approaching Maine.
Thank you.
Come on up, Mr. Jones.
Good morning, Mr. Jones.
Good morning, Your Honor.
Mr. Jones, you're before the court this morning on 2 counts. Each are a misdemeanor capias. They are charges for driving with a suspended license and having an unlawful license or tag sticker attached. I find probable cause. I'll hear from the parties.
Judge, we're just going to be requesting a phone order.
All right, anything else from the state? Mr. Linder, you have anything on this one?
No, Judge.
All right, then I will sign that order and I'll leave the standard bonds in place at this time. Carlos Fernandez.
He's in North Broward, Judge. He'd like to resolve this matter today if possible.
Thank you.
North Broward, Your Honor.
Thank you. Good morning, Mr. Fernandez.
Morning.
Mr. Fernandez, you're before the court this morning on count 1, disorderly intoxication in a public place causing a disturbance. Count 2 is for disorderly conduct or breach of the peace. I find probable cause. State, is there an offer for him? Okay.
Again, adjudication, time served, no return.
Is that what you'd like to do, sir? Adjudication time served?
Sure, yeah.
Okay.
Mr. Fernandez, there's also going to be a no return order. You understand that's part of the plea offer?
No return where?
To the location that this occurred at. It's a residence.
Okay. I don't know where it was at.
Do you want me to tell you the address?
Yes.
6401 Northwest 26th Street, Sunrise, Florida.
Okay.
All right. Okay. So, Mr. Fernandez, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah.
Thank you. You can put your hand down. Do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, I'm good.
Do you understand that you have the right to a trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Never.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served, and there will be a no return order as we discussed. Good luck to you, sir.
All right. Thank you.
Adrian Pozo.
Is approaching, Judge? Maine?
Thank you. Good morning, Mr. Pozo.
Morning, Your Honor.
Mr. Pozo, you're before the court this morning on a misdemeanor capias. This is a charge for trespassing. I find probable cause. I'll hear from the parties.
Judge, Mr. Poser was serving a state sentence. I believe his EOS date was yesterday. So on this misdemeanor offense, we're looking to resolve this matter. We want to see if the state had a plea offer.
state?
Adjudication time served.
It would be an adjudication time served. No
He
return.
wishes to accept the state's offer, Judge. He can't go back to allegedly where this took place. No problem with that.
All right, Mr. Pozo, will you raise your right hand? You swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Do you understand everything that we've discussed here so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you, Mr. Pozo. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served, and there's a no return order as discussed. Good luck to
Ma'am.
you.
Yes, ma'am.
Freddie Jones.
Yes, ma'am.
All right. Good morning, Mr. Jones.
Good morning.
Mr. Jones, you're before the court this morning on a misdemeanor capias. This is a charge for possession of drug paraphernalia. I find probable cause. I'll hear from the parties.
Judge, Mr. Jones wishes to resolve this matter. We want to see if the state had a plea offer for him.
Yes, the offer be adjudication time served.
Adjudication time served.
Yes, ma'am. He wishes to accept the judge.
All right, Mr. Jones, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Jones, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
I accept your plea and find that it is freely and voluntarily given. Mr. Jones, your sentence will be an adjudication, time served. Good luck to you. Next is going to be Olving Forrest.
I've been advised he bonded, Judge.
All right, I find probable cause. Roger Lininger.
I've been advised he is a medical reset, Judge.
Okay. Johnny Bellamy.
Mr. Bellamy, come on up, please.
I'm sorry. Okay, thank you. All right, good morning, Mr. Bellamy.
Good morning.
You're before the court this morning on count 1, driving with a suspended or revoked license. Count 2, having an expired tag that is not for magistrate. Count 3 is a traffic capias. I find probable cause, and confinement has advised that your bond has been posted. Thank you. Jeremiah Elliott.
Mr. Elliott, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Elliott.
Good morning, Your Honor.
Mr. Elliott, you were before the court on a misdemeanor capias. This is a charge for possession of cannabis. I find probable cause.
Judge, I'm going to be asking if the court would consider releasing Mr. Elliott, ROR. My understanding, he has a clean record. My understanding is, I believe law enforcement went to his grandmother's house to inform that they were looking for him for this misdemeanor of cannabis. Mr. Elliott went to the police station to surrender himself. He's looking for work. Judge, considering this is a misdemeanor of cannabis, I'm hoping the state has no objection having him released ROR on this offense.
considering he was in a program before Judge Solomon, and now I don't know what's gonna happen with that, I wouldn't have an objection to pretrial.
All right, I will, ROR Mr. Elliott, place him on standard pretrial. All right, Mr. Elliott, so that you understand, you're gonna be getting some information there about pretrial supervision. Once you are released, you must report to them within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that, sir? Okay. Jeremy Turner?
North Broward, Your Honor. Mr. Turner would like to resolve these matters if possible.
Thank you. Good morning,
North
Mr.
Broward.
Turner.
Yes, ma'am.
All right, Mr. Turner, you're before the court this morning on 2 misdemeanor capiases. These are charges for driving with a suspended driver's license, first offense, and operating without a valid license. I find probable cause. State, do you have an offer for Mr. Turner?
Served on each case.
Is that what you'd like to do, Mr. Turner?
Yes, sir.
Okay, we talked about the possibility of more license suspensions ending up in a 10-day county jail sentence, right?
Yes, sir.
All right, so make sure you get your license straightened out, and now the judge has some questions for you, so listen carefully.
Okay, will do.
All right, Mr. Turner, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. Mr. Turner, do you understand everything that's been discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
Yes, I have in the past.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, I fully understand that.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right. Thank you, Mr. Turner. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you.
All right, thank you very much. I sincerely appreciate it.
Duke Jonum?
Judge me.
Thank you. Morning, Mr. Jonum. Mr. Jonum, you're before the court on one count for trespassing or failing to leave property upon order by owner. I find probable cause.
Judge, that's me, Mr. Jonah. He wishes to resolve this matter. We want to see if the state had a plea offer.
Offer be a withhold court cause. It's not gonna be
Judge, he wishes to accept the state's offer.
All right. Mr. Jonum, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, Honor.
Okay, thank you. You can put your hand down. And Mr. Jonum, do you understand everything that we've discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you, sir. Zachary Watson.
I believe Paul Wright.
Thank you. Good morning, Mr. Watson. Mr. Watson, you're before the court this morning on 3 ad charges. Count 12 is for burglary of an unoccupied conveyance unarmed. Count 13 is for grand theft. Count 14, illegal use of a credit card. I find probable cause, and I'll hear from the parties.
Your Honor, Mr. Watson has no bond holds. I'm requesting a $2,500 bond on count 12.
That does appear to be the case, Judge, so I'd be asking for a reasonable bond on count 12. Leave the bonds on 13 and 14 in place.
All right, in light of the no bond holds that are currently holding Mr. Watson, I'm gonna place a $2,500 bond on count 12. I'll leave the standard bonds in place on 13 and 14. Thank you, Mr. Watson. Ryan Culpepper. Good morning, Mr. Culpepper.
Good morning, Your Honor.
Mr. Culpepper, you're before the court on an ad charge. Count 3, false imprisonment of an adult. I find probable cause. I'll hear from the parties.
Mr. Culpepper has a $150,000 bond on count 1 and a $50,000 bond on count 2, which I guess he probably can't make.
Of course not.
Yeah, that's not good neither. I'd ask the court for just a reasonable bond on count 3.
Your Honor, I'm requesting a $10,000 bond on count 3. Count 1 with a $150,000 bond is an allegation of sexual battery. This charge involves the same victim as in that case, or that charge.
I think Mr. Culpepper's most likely remedy is to go in front of his division judge and pursue a bond reduction there. Whatever
That's exactly what I need.
Yeah, I agree with
I'm
you.
innocent of all charges.
Okay, all right.
I have nothing to hide. I know I'm not supposed to talk right now.
Don't talk about the facts of your case. Don't talk about
I would rather talk though, because I've sat here since December 18th, maybe December 19th. I have yet to speak to a public defender. I've got a cookie cutter letter from my public defender at best. I'm innocent of all these charges. This is nothing more than a simple fist fight between.
Don't say anything. You just put yourself on the scene.
That's
So
that's fine. I can do that because I'm an innocent
Okay,
man.
all right, hold on one second, Mr. Culpepper.
Very frustrated with this whole
All right,
situation. because
Mr.
I have yet to speak to a
Culpepper,
public-
Mr.
Yes,
Culpepper,
ma'am.
just hang on 1 second, all right? Now, first of all, let me just ask Mr. Reedy, is there a PD that's been assigned to his case? Perhaps it's somebody that you can reach out to following this morning's hearing?
Rachel Gilbert has filed a notice of appearance.
Okay. So, Mr. Culpepper, I would imagine that Mr. Reedy, who is here from the Public Defender's Office with me this morning, will reach out to the specific attorney who's been assigned to your file following this morning's hearing. And based on that, they will likely be putting you in front of your division judge shortly to address the bond issues. So for today's purposes, just for my purposes this morning,
Yes, ma'am.
the ad charge is gonna have the $10,000 bond on it in light of the other bonds. And I would imagine that based on our conversation here this morning, someone from the Public Defender's Office will be reaching out to you very soon
I
to
hope so. This is
discuss
nothing but a
these.
fabrication
yeah,
of
no,
lies.
I understand, Mr. Culpepper. It does appear as though your public defender spoke with your father earlier today.
Okay, so at least
Around
we've
9
got
o'clock
some-
this morning.
We've got some movement going on it, okay?
So I'm going to send her an email and ask her to put you at the top of the list for her to go to jail and see, okay?
These are some rather disturbing charges that are nothing more than I
All
said.
right, listen, this isn't the time to resolve it, though.
All right, so Mr.
I wish it
Culpepper,
was.
they're gonna be in touch with you shortly, okay? Just be patient.
Thank you very much.
Thank you. I'm sorry. Yeah, so that'll be added on. Do you need me to write that on there? It's a pretrial level 1. Okay, Michael Catania. All right, good morning, Mr. Catania.
Morning.
Mr. Catania, you are here on 3 ad charges. Count 10 is for burglary of an unoccupied dwelling unarmed. Count 11, first-degree petty theft. Count 12, criminal mischief. I find probable cause. I hear from the parties.
Yes, Your Honor. I'm requesting a $5,000 bond. Again, Mr. Catania is appearing before the court accused of breaking into a building's laundry room again. He's got a $25,000 bond on a burglary, same exact allegations with the GPS monitor. He's got numerous open cases, all involving the same allegations, different buildings, breaking into the laundry rooms.
Mr. Reedy.
And just judged by Mr. Catania's demeanor, that this is really,
Is he, on the other counts, was he being, aside from the monetary bond, is it pretrial with the GPS?
I don't know if, because there was a bond surrender on some of them, I would just ask for GPS on this count.
Is there, what is he, what do we have on him for the other one? Mr. Reedy, you have anything you want to add?
No, Judge.
All right. Count 10 will have a $5,000 bond. If he posts the bond, it'll be the same conditions as the other charges, pretrial, level 1 with the GPS. Thank you, Mr. Catania. Patrick Ware.
Judge is here present.
Thank you. Good morning, Mr. Ware. Mr. Ware, you're before the court this morning on 2 ad charges. Count 8, false ownership information provided for pawned items, $300 or more. Count 9 is for grand theft. I find probable cause. I'll hear from the parties.
Judge, and speaking to Mr. Ware, he advised me he actually went to court yesterday on the other matters that were holding him.
Yes.
He had, I believe, a monetary bond. After speaking to the judge yesterday, my understanding is Mr. Ware was released on pretrial release. I believe when he was being, they ran these 2 additional charges came up, so we're asking on these nonviolent offenses to have Mr. Ware released on pretrial release.
Your Honor, he has an out-of-county no bond hold. I don't know what Judge Casey was aware of and wasn't aware of, but since he's not going to be getting out of custody anyways, I'd ask that the court keep the bonds in place. And if Judge Casey determines once he is advised that there's additional criminal allegations, that it's still appropriate for a release to pretrial, then he can do that as well. He also has $100 bonds on felony petty theft and resisting without violence.
Now, Judge, I wasn't there, but in speaking to Mr. Ware, he informed me that the judge did know as far as the out-of-county no bond hold. He was informed also that Mr. Ware unfortunately suffered a loss. His mother passed away. So the first step in order to try and see if he can somehow get out would be for him to be released, so then that other county can come and pick him up and hopefully over there talk to the judge over there in that county. But at this time, Judge, we're still maintaining our request. We're still, as Mr. Ware, to be released on pretrial release.
Just to be clear, I didn't claim that Judge Casey wasn't aware of his out-of-county hold. I said he wasn't aware of these charges, which he couldn't have been because they hadn't been dropped on him yet.
He gave me pre-trial release so St. Lucie County can come pick me up so I can resolve the problem.
Okay, let me just confirm with confinement. Yes. Okay, so what I'm being told by confinement is that he was before Judge Casey on a violation of pretrial. He put him back on pretrial for those charges, but there are other charges not related to that remain open, and therefore confinement is telling me he's not going anywhere until those charges are addressed as well. And those are aside from what I'm dealing with this morning.
Oh, those are aside?
No, only have these charges. These charges right here.
No. Hector, he's got a $100 bond on a petty theft and resisting without violence. Also, the out-of-county hold is on a VOP. The other county's not, St. Lucie's not going to take him until he's done with his local charges.
Judge, if I heard correctly, I don't think there's, other felonies. The other felonies would be these two that are here before you. Now, I understand
That's
Mr. Lunder mentioned a misdemeanor $100 bond, but on the felony offenses, then we're still maintaining our request as far as having him released on pretrial.
What I'm saying is, unfortunately, it would appear Judge Casey was given bad information.
Well, I can't hear you.
It would appear Judge Casey was given bad information if he was led to believe that just releasing him on the local charges would get him to St. Lucie County. What I'm being advised is he's not going to St. Lucie County till he's done with his local charges.
So in other words, he's not going to be going anywhere anyway. That's the issue. And I'm not sure if there's a misunderstanding with Judge Casey or a misunderstanding between Mr. Ware and his attorney. But based on the information that is being confirmed to me, both what Mr. Linder just stated and what confinement has confirmed with me, he is not going anywhere until these charges are addressed. That means that a no bond hold is effectively in place. So based on that, I'm going to leave the standard bonds in place at this time. Stefan Iparaguer.
Good morning, Your Honor.
Good morning, Mr. Iparaguer. You were before the court this morning on count 1, robbery, no firearm or weapon. Count 2, battery, causing bodily harm. Count 3, illegal use of a credit card. I find probable cause, and I'll hear from the parties.
Your Honor, I'm requesting a $7,500 bond on count 1, a $2,500 bond on count 2. No victim contact. This is based on the level of violence. Allegedly, the defendant attacked the victim twice, striking him in the face multiple times, causing lacerations that caused the victim to bleed from his face. When the victim went into the establishment to clean his face, the blood off of his face in a bathroom, the defendant followed him in there and struck him again multiple times. There's independent witnesses to this incident, and the defendant, when located by law enforcement, had the victim's property in his possession. He's out right now on a DUI from about a month ago. He had a trespass 2018, attempted burglary of a conveyance 2016, burglary of a dwelling 2015, strong-arm robbery 2015, where he was sentenced to 3-year state prison, attempted burglary of a conveyance 2012, grand theft 2011, burglary of a conveyance 2010, and one moment, Your Honor. Also noting that there was a witness that advised law enforcement of what occurred, corroborating the incident. And I do have a concern that the defendant apparently made references to gang affiliations.
Judge, this being Mr. Paragira, he advised me he's looking forward to contesting these allegations. He advised me he also has a witness. I believe this took place at a local establishment or a bar or something like that, in which he advised me that he was the victim first approached him and he was defending himself. So obviously we're not going to know exactly what happened today. He's 27 years old, been here his whole life. He just got a job 2 weeks ago. He just started at a company called Flex and Stay. He just got his first paycheck. He got $400. He lives in Sunrise with his father. He's going to be reaching out to his father to help post his monetary bond, but he doesn't think he can afford anything, so he's also going to be reaching out to his girlfriend, but she's a student, not employed. Judge, I was going to be asking for a $4,000 bond on count 1. I was going to be asking for a $1,000 bond on count 2, so I was going to be requesting a total of $5,000 on Mr. Paragira's behalf, Judge.
To believe Mr. Romero's representation of what occurred, you have to believe that the defendant, while defending himself, somehow ended up in possession of the victim's wallet and phone, which he decided to use his debit card to purchase drinks.
Placing a $5,000 bond on count 1. There's going to be a $2,000 bond on count 2. There's also going to be a no victim contact order whether Mr. Piragiri knows this victim or not, so that you understand, sir. No victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am. May I ask you a question? One moment. Yes, sir. Judge, nothing to add at this time.
Okay, thank you. Jermaine Smith?
I believe North Broward. Jamie and Smith.
North Broward, do you have Jermaine Smith?
Medical reset, Your Honor.
Oh, you got another one for me. Thank you.
Sorry.
Jerry White?
So wait, are we not resetting Jermaine?
I'm sorry, what was it on Jermaine Smith? Okay, let's hold on 1 second. We gotta address Jermaine Smith may not be reset. All right, thank you. Can I see Jermaine Smith's? If it's a KPS, I can find probable cause anyway. All right, so on Jermaine Smith's case, for the record, I find probable cause, and he will not need to be reset on our docket. Okay. Jerry White?
He's a person, Judge. He's here in name. He declined the services of public defender. I believe he wants to see if his bond's been posted.
Okay. Good morning, Mr. White.
Good morning.
Mr. White, you're before the court on 1 count of grand theft. I find probable cause and confinement has advised your bond was posted.
Okay, thanks.
Thank you. Jonathan Celestin?
He's approaching, Judge.
Thank you.
Judge, Mr. Celestine advised me he has private counsel. Mr. What's his name? Andrew Ryer. Andrew Ryer? Yeah.
So I spoke with Mr. Ryer this morning, Your Honor, and he indicated he would not be able to attend today. But I did advise him that Mr. Celestin has a court date tomorrow morning in front of Judge McCarthy, and he will be there at that time.
Okay, so Mr. Celestin, just for the record, you're before the court this morning on counts 1 through 4 are each for a felony KPS with a no bond hold that is not for magistrate. Counts 5 and 6 are each a misdemeanor KPS. I find probable cause, and based on what you just heard a few minutes ago, you do have a hearing before your division judge tomorrow morning, and your private attorney will be present at that time.
Okay, yes, Your Honor.
Thank you. James Kazoo? Kazoo? Good morning, Ms. Kazoo. Mr. Kazoo?
Good morning.
Mr. Kazoo, you are before the court on 1 count of aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I'll hear from the parties.
Your Honor, this is a filed case, and I reviewed some of the supplemental reports that were provided in addition to the probable cause affidavit. What causes me some concern is it would appear that there were additional threats sent to this individual, the victim in his business, text messages before this occurred, threatening violence against him if Mr. Kazoo's car was not released to him by the company. What causes great concern is that it does appear he then followed up those threats by going to the location armed with a firearm and threatening this individual. Let's see. What's that? He does have drug dealing priors out of date. Those are a bit dated. It was 2009. in light of the threat with the firearm and the additional threats that were made, I'm requesting a $10,000 bond, no victim contact, no return, no possession of firearms, weapons, ammunition.
Carol?
Judge, in this case, I'm certain there's two sides to this story. My understanding is this alleged incident happened well over a year ago. My understanding is I believe the alleged victim is a tow truck employee, in which my understanding is that the vehicle was improperly towed. I believe Mr. Cazot made follow-up, visits or try to contact that company in order to get back his vehicle. Bottom line, that was the main thing that he was trying to do. Now, my understanding is Mr. Cazot also followed up with law enforcement on the day his vehicle was towed. He actually contacted law enforcement, and then he also followed up with law enforcement on one other occasion. He's been living here his whole life. He's 34 years old. As you heard, he basically has no recent contact with the criminal justice system. As a result of his vehicle getting towed, it had a whole domino effect. He lost his job. At this time, though, things are going better. He's working. He was working as a security guard. He's been there for about 3 months, making about $10 an hour. He lives locally in Pompano Beach with his girlfriend. They pay about $500 a month in rent, from what he advised me right now. Even though he's doing better right now financially, he's not going to be able to afford to post a monetary bond of $10,000. What he's asking the court to consider is a $2,500 bond on his behalf, and he believes that's something that his girlfriend will be able to afford, Judge.
And just to let you know, it does mention in the supplemental reports, there was a witness, an employee of the business, who gave a statement to law enforcement that he witnessed the altercation and he saw Mr. Cazot in possession of a firearm.
What's the most recent firearm?
It's a 9.
$500 bond. The additional release conditions are going to be no victim contact, no return, and Mr. Cazot is not to be in possession of any weapons, firearms, or ammunition. Mr. Cazot, with relation to those orders, no victim contact means no phone calls, no text messages, no social media, no third-party contact. No return means you are not to return to the location that this incident occurred at. No weapons means that if you are in possession of any weapons, firearms, or ammunition, you are to surrender those to law enforcement until further order of the court. Do you understand all those things?
Yes, ma'am.
And not that it needs to be discussed here at first appearances, but for the record, because it was brought up earlier, whether or not this vehicle was illegally towed or not, that's obviously never a circumstance that provides for someone to take the law into their own hands. So whether it happened or not, I feel comfortable making that statement today based on the representations that were made this morning.
How much was the monetary bond, Judge?
$2,500. Barris Singletary.
Mr. Singletary is approaching.
Thank you. Good morning, Mr. Singletary. You're before the court this morning on 3 counts. Each is for a felony probation violation. I find probable cause. And Mr. Singletary, each of these has a no bond hold, and you will have a hearing before your division judge tomorrow morning to address this matter. Shaheem Jean-Philippe.
He's approaching Judge Main.
Thank you. Good morning, Mr. Jean-Philippe.
How you doing, Judge?
I'm good so far. So, Mr. Jean-Philippe, you are here this morning before the court on count 1, possession of cocaine. Counts 2, 3, and 4 are each felony violations of probation. Counts 5, 6, and 7 are also felony probation violations. Each of those has a no bond hold. I find probable cause. And Mr. Jean-Philippe, you have a hearing before your division judge tomorrow morning. So in light of that, I'm going to leave the standard bond in place on count 1. Thank you. Marvin Burrows.
Judge, medical recess.
Thank you.
Mr. Glover.
Dante Glover.
Approaching Judge Main.
Thank you. Good morning, Mr. Glover. Mr. Glover, you're before the court this morning on 1 count of battery on a person 65 years of age or older. I do find probable cause. I'll hear from the parties.
Judge, my understanding is I believe the date of incident is back in around July of 2017.
That's correct.
Mr. Glover does not reside in South Florida any longer. He actually resides in Jackson County, which is by the Panhandle. He was extradited down here. He's been in custody ever since January 2nd, so about 2 weeks now. Judge, my understanding is he lives in Jackson. He lives there with his mother. His mother knows he is here. Right now, Mr. Jackson he's already done the paperwork. He was actually scheduled to start police academy on January 6th. Obviously, that's going to throw a wrinkle in that. But my understanding, Judge, his mother is going to be the one that's going to be posting his monetary bond. We're going to be requesting, I believe he has pretty much a clean record. I'm going to be requesting a $1,000 bond on Mr. Glover's behalf, Judge.
State.
Requesting a $3,500 bond. I understand when this occurred, but also, Your Honor, I would also note the age of the alleged victim, that it would appear that Mr. Glover and his brother both attacked this individual and caused the injury that required medical assistance and treatment.
Does he have priors?
I'm not showing anything, Your Honor.
All right, I'll set the bond at $1,000. There will also be a no victim contact order. Mr. Glover, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Thank you. Alan Lund.
Judge, I believe confinement status has some information for us.
He's been removed, okay. Daniel Castro.
He's approaching, Judge.
Thank you.
Come on up, Mr. Castro.
Good morning, Mr. Castro.
Good morning or afternoon. I'm not sure what time it is.
It's still morning, believe it or not. All right, Mr. Castro, you were before the court this morning on count 1, driving while license suspended, habitual. Count 2 is a felony probation violation with a no bond hold. Count 3 is for a felony out of county hold, which also has a no bond hold and is not for a magistrate. Count 4 is a civil out of county hold, and that is not for magistrate. I find probable cause. I'll hear from the parties if they wish to be heard.
No, Judge.
Mr. Romero, you have anything you want to tell me on count one?
One moment, Judge. What I was explaining to him, unfortunately, with the VOP, with the out-of-county, there's nothing we can do on that, and that's what I was explaining to Mr. Castro. So the only thing I did advise him that the court has any sort of discretion on what to do is a monetary bond associated with count one.
Correct.
So he's requesting an ROR on count one.
The judge's power. You know, I recently started a dog business. I'm a dog breeder, and I have 28 dogs at home. My wife, who was also arrested with me yesterday, is the only person who can kind of take care of my animals. So it's it's a stressing situation, being as to how my license was taken away from me for child support. The next week I ended up paying $15,000 in child support to get my license back. So when I do go to court, they take my license away anyway because I got charged with driving with a license suspended the day before I paid off my child support. So I'm in a catch-22 situation that keeps on lingering, and I just want to resolve this. I'm a law-abiding citizen. I own my own business. I have my own LLC, and I have a dog show that can potentially make me up to $15,000 on puppy sales that I'm gonna miss out on because of this. So I just really want to get out out of this county, go take care of what I got in my county, and get up out of here. Y'all have a good day.
Your Honor, first of all, and just so Mr. Castro is aware, if he has concern for the welfare of the animals and he doesn't know anyone he can contact, the state, or I have no issue contacting law enforcement to do a welfare check on those animals. And if they have to remove them from the home, then they'll do what they have to do. That being said, I don't know if he wishes for that to happen.
Judge, I think as far as that specific issue, that issue is being addressed from what Mr. Castro advised me.
Okay, so the dogs are going to be all right. So that being said, he's on probation for the same offense that he committed, the new offense he committed. Based on that, Your Honor, I really see no reason to mitigate, and that the bond should be kept at $750.
Probation violation on count two, that's also, they're all from Hendry County, is that correct? All right. All right, based on what's going on here, I'm comfortable with RORing Mr. Castro on count one.
Thank you, ma'am.
So that you understand, Mr. Castro, and I'm sure that Mr. Romero has explained this to you, even though you're getting ROR'd on this case, number one, it does not mean that this case is over. So you are going to have to come back and deal with that. Okay, you need to keep in touch with your attorneys in the clerk's office about it. And number two, from what I'm seeing here, you're going to end up being taken to Hendry County so that you can address those issues. So I hope that somebody is taking care of the dog situation, because it doesn't look like you're going to be home anytime within the next few days based on what I'm seeing, okay?
Right.
All right, good luck. Taria Skirley,
He's approaching, Judge.
thank you. Morning, Mr. Gurley. Mr. Gurley, you're before the court on one count of carrying a concealed firearm. I find probable cause. I'll hear from the parties.
Judge, nothing to add from the defense. I'm going to be contacting his mother to post his monetary bond.
Thank you. State.
That's for an order, no firearms.
All right. So the standard bond will remain in place. There will also be an order that Mr. Gurley possess no firearms or ammunition. Mr. Gurley, understand that if you are in possession of any of those items, then you are to surrender them to law enforcement. Do you understand that?
Yes, ma'am.
Thank you. Ivan Campos.
Mr. Campos is approaching, Judge.
Thank you. Mr. Campos, good morning.
Good morning.
Mr. Campos, you're before the court on count 1, burglary of an occupied dwelling unarmed. Count 2 is grand theft, 3rd degree.
It should be unoccupied.
This should be unoccupied. All right, I'm gonna cross it out and write unoccupied. All right, I'll hear from the parties.
They request a $7,500 bond, no victim contact, no return. I see no history, but this did involve someone's home. Mr. Campos was in a position of trust as he was doing work on the home, specifically the roof, took advantage of that position to commit a burglary of the victim's residence.
Judge, I understand on the surface it looks bad. However, my understanding is, as the state pointed out, he had permission to be in the property. He was actually working on the roof. The company's called Foam Bright, where he's been there for about 7 years. My understanding is he was cleaning the top of the roof. My understanding, I believe we're dealing with a drill bit or something like that, or something along that nature. Now, Mr. Campos
For
is
the,
not the
Mr.
man-
Romero, not to interrupt you, but I know you haven't seen the probable cause affidavit. For the record, it's a Porter cable cordless nail gun and battery.
Nail gun.
Not a drill bit.
Nail gun. Okay, so a nail gun. My understanding, Judge, is this is something that Mr. Campos is telling me was there's an explanation for it. Bottom line, Judge, is he was working for a company. The homeowner, I believe, contacted that company to have Mr. Campos return. Mr. Campos did return, and I believe the merchandise was recovered out of his truck. And then that's when Mr. Campos tried to explain to law enforcement as far as the circumstances, but ultimately he was arrested. However, Judge, he has no prior record. He's a registered voter in our community. He did apply for the public defender. He's going to be in contact with the public defender so that he can contact the case file to let him know exactly what was going on. But Judge, I don't believe he's a flight risk. I'm going to be asking for the court to consider a $2,000 bond on count 2. I'm going to be asking, right now I see it set at a $5,000 bond. I believe this is a standard grand theft. I thought the monetary bond would be $1,000. I'm going to be asking for a bond reduction to $1,000, Judge. I'm asking a $3,000 total bond on Mr. Campos' behalf.
It's not the standard bond when you steal from someone's home, and that's why it's raised.
Judge, ultimately, if he's there and he has permission to be there, I don't know how far a burglary is going to go. Maybe just the grand theft count 2. I don't know, but there's more to this story, Judge.
And Your Honor, and I know the court is already aware of this, I just have to respond, because again, Mr. Romero hasn't seen the PC. He had permission to be on the roof. That's where he had permission to be. And I don't know what explanation there could be for him being in possession of a nail gun, because he was hired to clean the roof. And you don't need a nail gun to clean a roof.
Judge, just common sense tells you if a person's hired to be on a roof, course, he's gonna have to go to, have access to other parts of the property. That's just common sense. He's not just gonna magically appear on a roof.
Mr.
But that's
Romero,
not for today.
if you would like for me to read you the probable cause affidavit aloud into the record, I'm more than happy to do so. But I'm not sure how well-founded those statements are at this time. The representations that Mr. Campos are giving to you, if they are in line with what you're telling me, I'm not sure how far that story's gonna go. So, just so that you're aware. All right. On count one, I'm going to impose a $2,000 bond. The standard bond will remain in place on count two. There's also going to be a no victim contact order and a no return order. Mr. Campos, so that you understand, no return means you are not to return to this residence for any reason. Number two, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes.
Thank you. Charles Johnson. Good morning, Mr. Johnson.
Good morning, Your Honor.
Mr. Johnson, you're before the court on count one, second-degree petty theft, third or subsequent offense. Count two, resisting an officer or obstructing without violence. I find probable cause. I'll hear from the parties.
Judge, Mr. Johnson's not in a position to post any sort of monetary bond. Right now, he's requesting for the court to consider releasing him pretrial release. Right now, he's just trying to establish himself here in Broward County. He just moved down here from South Carolina. He's been here about 9 months. He's 47 years old. He lives locally here in Fort Lauderdale, where him and 3 other roommates are renting an apartment. I believe his share is about $200. But from what he advised me, no one's going to be able to afford any sort of monetary bond for him.
Your Honor may recognize Mr. Johnson. He appeared before you Monday afternoon on a motion to release where you granted his release and he was ROR'd. He was released on the 14th, and now the next day he gets arrested for committing a theft at a Home Depot. And he was ROR'd on a grand theft. Also at a different Home Depot.
Standard bond in place at this time. There's also going to be a no return order. Raymond Gonzalez.
Judge, I've been informed he bonded.
Yes, thank you. I find probable cause. Andrew Innocent.
Please approach the judge.
Thank you. Good morning, Mr. Innocent. You're before the court on one count of carrying a concealed firearm. I find probable cause. I'll hear from the parties.
Judge, nothing to add from the defense. I'm going to be contacting his uncle to post his monetary bond.
Just ask for an order of no firearms, Judge.
All right, the standard bond will remain in place. There will also be an order that Mr. Innocent possess no weapons, firearms, or ammunition. Mr. Innocent, that means that if you are in possession of any of these items, you are to surrender them to law enforcement. Do you understand that, sir?
Yes, ma'am.
Thank you. Douglas Rivas Benitez.
Here at main, Judge. Good morning, Your Honor.
Thank you. Good morning, Mr. Benitez. You are before the court on count one, possession with intent to sell, manufacture, or deliver cannabis. Count two, possession of cannabis over 20 grams. I find probable cause, and confinement has advised that your bond has been posted, sir.
Yes.
Jeffrey Bernard Marshall.
Please approach the judge.
Thank you. Good morning, Mr. Marshall.
Yes, ma'am.
Mr. Marshall, you're before the court this morning on Count 1, petty theft, second degree, first offense. Count 2 is a felony probation violation with a no bond hold. I find probable cause. And Mr. Marshall, you have a hearing before your division judge tomorrow morning. So in light of that, I'm going to leave the $25 bond in place on count 1, and you can address that tomorrow.
Yes, ma'am.
Thank you.
Thank you.
Christopher Seed.
Who's the person, Judge?
Thank you. Good morning, Mr. Seed.
Good morning, Your Honor.
You're before the court on count 1, possession of cannabis, 20 grams or less. Count 2, possession with intent to sell, manufacture, or deliver cocaine. Count 3, possession or use of drug paraphernalia. I find probable cause. I'll hear from the parties.
Judge, nothing to add from the defense at this time.
Okay. State. All right, in light of that, the standard bond will remain in place on count 2. Thank you. Jarvis Crawford. Okay. All right, good morning, Mr. Crawford.
Good morning.
Mr. Crawford, you're before the court on a few ad charges. Count 4 is for fraud or uttering a false instrument. Count 5, misrepresenting self or committing personal identity fraud. Count 6, petty theft, second degree, first offense. Count 7 is a felony probation violation which has a no bond hold. I find probable cause.
Your Honor,
yes.
Mr. Crawford is already being held no bond on the same VOP prior to these new charges. Just requesting that the standard bonds be kept in place.
That's fine. I understand he has a court date tomorrow,
Yes.
so
All right.
he'll need to go in front of Judge Merrigan.
Okay. I'll leave the standard bonds in place, and Mr. Crawford, you'll be seeing your division judge tomorrow morning.
Okay, thank you.
Thank you. Norris Collins. Yes.
North Broward, Your Honor.
Thank you. Thank you. All right. Good morning, Mr. Collins.
Good morning.
Okay, so Mr. Collins is here this morning on, he's got a change of charge as well as 2 ad charges. Is that correct?
That is correct, Judge.
All right, so count 1, I just want to make sure. Count 1 has been changed to attempted burglary of an occupied structure. Is that correct?
That's correct.
All right, and counts 2 and 3 are the ad charges. Those are for touch or strike battery and criminal mischief, $200 or less. Let me just take a look at the probable cause affidavit. Okay, all right. I find probable cause, and I'll hear from the parties.
Your Honor, based on the totality of the circumstances, I'd be requesting a $3,500 bond on the attempted burglary of the occupied structure, considering there was also allegations of violence involved. His history includes theft, resisting without violence, and trespass last year. theft last year, criminal mischief 2018, theft 2018. He was arrested on failing to appear in court on 2 separate thefts last year and then another theft in 2018.
Well, Judge, I can say that Mr. Collins has been living here for the last 18 months. He does reside by himself. He is looking for a job at this point in time. He has an AA degree as far as his educational background is concerned. He's been able to provide me with the numbers of his brother and his mother, who I intend to contact after court to see if they can help him post bond. But I don't know how much money they're going to be able to come up with. I have a feeling it is not going to be all that much. So I would ask the court to take that into consideration when setting bond on count 1.
Do you have a recommendation, Mr. Reedy? Do you have a recommendation as to amount?
I'd ask for a $1,500 bond, Judge.
Based on everything that's been discussed today, the bond on count 1 will be set at $2,000. The standard bonds will remain in place on counts 2 and 3. There will also be a no victim contact order as well as a no return order, Mr. Collins, so that you understand. No return means you're not to return to the location that this alleged incident occurred at. And no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yeah, I understand that,
Okay.
but.
I'll call your mother and your brother for you.
Okay. All right. Thank you, Mr. Collins. Jerry Decius.
He's in Paul Ryan, Your Honor.
Thank you.
I spoke with his attorney, and he indicated to me that he could be here at 1 o'clock. So I've asked that Mr. Decius be reset till 1, which may be why he's not there in the jail right now.
That's very possible. Mr. Linder, do you have something you wanted to say on this?
No, I'll address it at 1 o'clock.
Okay. So I'm going to hand this to the clerk. Michael Cooper.
I believe the main jail, Your Honor.
Thank you. There's no one left at Maine. There's Mr. Romero.
I'm here, Mr. Cooper, on what page, Judge?
What page is Mr. Cooper on? What is it? 32?
I'm gonna tell you right now. Medical loan, Judge.
All right. Jeffrey Clark.
I would just ask
Yes.
Mr. Cooper if the court would be willing to make a PC determination, and then he could be reset for bond purposes.
That's fine. Based on the. Good morning. One moment. Okay, based on Mr. Cooper's case, based on the probable cause affidavit, I do find probable cause for the charges of possession of MDMA and trespassing, and he can be reset for bond. Okay, then let me go to Mr. Clark. Where is Mr. Clark?
North Broward, Your Honor.
Thank you very much. All right. Hi, Mr. Clark.
Good morning, Your Honor.
All right, Mr. Clark, you're here on 2 ad charges. Counts 3 and 4 are both counts for second-degree petty theft, third or subsequent offense. I find probable cause, and I'll hear from the parties.
Your Honor, Mr. Clark's being held no bond on a violation of probation, felony violation of probation on counts 1 and 2.
Okay.
I would just ask that these bonds be kept in place.
Mr. Reedy?
That's fine, Judge, as I discussed that with Mr. Cooper earlier today, or Mr. Clark earlier today.
Okay. All right. So in light of the no bond hold, I'm going to leave the standard bonds in place on these 2 ad charges, and Mr. Clark can go before his division judge. Thank you, Mr. Clark.
Thank you.
Fan Delisma?
Oh, can we reset him?
North Broward, Your Honor, he's out to court.
Okay, so he'll be,
Your Honor?
yes.
I would just ask if the bond could be This is, on Fanfan Delisma, it's a lateral change of charge. He's being held no bond on a violation of pretrial on another case. I'm just asking that the original bond be placed back on him, $2,500, and there was a GPS.
That's fine, Judge. He is being held no bond on a, looks like an aggravated assault
Okay.
court order.
All right, that's fine then. And I see he has a hearing for his division judge tomorrow. So Delisma, I find probable cause on the battery charge. Bond will be set at 2,500, which is what it was at before. And what were the other conditions of release? Okay. All right, so it'll stay the same. Okay. All right, so that's it for our morning session. Do we have something else, Mr. Linder?
Well, I apologize. So Decius is the case we reset for the PM?
No,
Okay.
it's not being reset.
Decius?
That's, excuse me.
Decius should
yes,
be reset. Okay.
Decius is being reset.
Just want to make sure. Okay,
Correct.
thanks.
Yep, I had Decius and Delisma.
Yeah.
Okay, so that'll be reset for this afternoon. All right, so I will see everyone this afternoon for our PM docket.